tort features. I want to believe that when they gave you the introduction, you understand the principles of tort features. So you can actually just argue that both of them should be sued in tort, right? Okay. I want to believe that when they gave you the introduction, what's wrong with this YouTube thing that it's just so you can actually just argue that both of them, and we have to live stream in tort, right? Oh, okay. I want to believe that when they gave you the introduction, what's wrong with this YouTube thing that it's just so you can actually just argue that both of them, and we have to live stream in tort. Okay. Let's go ahead. Can you hear me? Can you hear me? Okay. When we get there, now we picked issues. Are you sure there's no other issue on this in this question? Towards the end.
Ma, there's also the issue of Honorable Eggy, I think, yeah, Honorable Eggy threatening Professor Small via public TV or nationwide through nationwide television.
Okay. So what does the issue portend? What does it suggest?
It says maybe like whether the threat of Honorable Eggy towards Professor Small can be a basis for false imprisonment.
Really? Are you sure
because,
that's what we're talking about?
Constitutes assault. Constitutes assault, ma.
Assault. Okay. So Abib, your hand, you have something to contribute. Another question.
Yes, I wanted to point out the threat aspect of these issues now.
Okay. So the threat, when you have identified whether it's an assault. Now, if you want to rephrase that, what exactly is in that threat? What is special about this threat? Threatening someone on TV. Amongst the principles of, okay, let's even wait. I don't want to, if I talk, I'm going to end up answering your questions for you. So you have picked up all the forms of trespass to persons in this question. How would you now begin to answer your various issues? If you are in the exam, are you going to answer them the way you have picked them? Fine. But you see, you can save yourself some time by doing something. Because if you are not careful, you end up repeating some things over and over again. Now, can somebody tell me what they can do to give a structured answer to this question? You have picked out all these issues. I agree with you. When we are talking now, we are going to make those issues more specific. But now, let's see. In terms of answering the question, the first issue that you picked issues on assault, battery, false imprisonment. Anyway, let me guide you a little. If I were you, all the ones that relate to assaults, I'll put them together for discussion. The ones that relate to battery, I'll put them together for discussion. And the one that relates to false imprisonment, I'll put them together for discussion. Can you hear me?
Yes, ma.
Okay.
But ma, how do we say it? Like, if we want to write it, would we say that in this answer, I'm going to be treating all the questions and all the issues relating to assault?
You can say that because you must carry the examiner along, but you don't have to really say you have picked the issues related to assault. Then you might just say yes, I want to treat all the issues that relate to assault in this question, and say one issue, and you can title it issues dealing with assault. And then you write out the issues. A, what are the issues dealing with assault? You've picked the issue of what now? You pick them out. Then you have satisfied the question of issues, identifying issues. B, what is the rule? Then you discuss assault and its principles. You discuss the principles relating to assault. Can you hear me? What is assault? And what are the elements? Within the discussion on assault, they've talked to you about some minute things that you can find in your questions. Somebody tell me the meaning of assault. Let me just be sure I'm not talking myself. Obafemi Grace.
Good morning, ma.
Good morning.
Ma, I have a question about what you just said. So my question is, so if looking at this question, if we do not like list each issue the way they come, so like there's nothing wrong in that, right? Because you just said that you
Yes, I
advise us
said
to. Okay. Thank you, ma. Just
you pick
wanted
all
to
the issues out.
clarify.
Fine. By the time you are picking the issues, maybe you are not your mind was not so settled. It's the first thing you are doing. As you are going up and down reading the question, you now saw that there's another issue. You are listing the issues. So there's no problem with that. But now you want to answer the question. And that's why I said now you can actually put issues that with each principle together. Because for you to discuss in the exam, you have to define the principle, define the assault, tell us the elements, and then whatever. So if you don't put the ones that deal with assault together, you have dealt with assault by Professor Egi, you define it, you give us the elements, then you go to forced imprisonment, then you go and define that one, then you come back again to another issue of assault. Are you going to start say, I adopt what I said in question in the first part? You cannot say that. So that's what I'm saying is better. You have seen that there are some areas of the question that deal with assault. So list those areas. I say the issues that bother the aspects of the question or the issues that bother on assault are A, B, C. And then you begin to talk about the law relating to assault. Then when you have talked about the law relating to assault, then you pick issue one, the issue of Honorable Egi splashing water. Throwing a microphone at Professor Small. After discussing it, you think that is assault? Do you think that is assault? I told you I'm not going to tell you the law or be asking the questions for you. I'm just giving you structure and expectations about examinations. Who is up now?
Thank you, ma.
Yeah, who is ready to tell us? You have picked out the issues. You know that some of them are dealing with assault, Honorable Egi's action, Honorable who else now? Who else now? Assault. I told you to list the issues, so I'm not going to answer them for you. Nelson. Nelson.
Good morning.
Yes.
I have a question on the structure that you said we should adopt. So if I'm to get you right, we'll talk about we'll talk about the principle of assault first, like just like the rules first. And then we'll not start writing the issues down on SMA.
I'm sure you have heard the principle of hierarchy before. And what I'm saying is not strange to you. You have brought out the issues. If you are saying these are the issues, you are going to tell us the law. You are going to define assault. You are going to tell us the elements of assault. And then you will now quickly focus more specifically on the aspect of assault that is brought into question here. And those aspects relate to what? The actions of who and who. So definitely you are going to tell us the law. That is the essence. You are not just going to tell us the issue is whether this person is liable to assault. And then I think that he's liable to assault because when you throw something at someone, then it is an assault. When you threaten someone, it is an assault. That is just a conclusion. You will lose all the marks if you don't tell us the law. It cannot be an assault. You cannot convince me that it's an assault until you have told me what the law is. So you brought out the issues. What they call rules in the hierarchy that people are using is law. What is the law? Okay, when you have told us what is the law, then you apply that law. Throwing a microphone at someone, even when it did not hit the person, does it constitute an assault? Okay. Threatening someone on telly. By threatening someone on telly, Is it an assault? The person is on television, it's not near you. I think that is suggesting something to you. So you have to give us the principles, the elements of assault, and the various applications. When you have done that, is when you apply it. So taking the assault one as an example, what are the elements? I want us to finish this thing and go to the next question because it shouldn't take us this long time. Okay, I take it that you know it. Zion, your hand is up. I will take the next issue if you are. Zion.
Yes, ma, it's the elements. Can I see them?
Yes.
Okay. That there was a threat to apply force and that the act will put a reasonable person in fear of battery.
Okay. What other issues were they discussed with you in assault? Little issues. Element. Yes.
Okay, that the mere
Yes.
words constitutes assault.
Mere
Like
words.
as mere words.
Okay.
Like as in the case of when Professor Honorable Eggy was threatening Professor Tweet on the TV, would that constitute to assault?
Exactly. Now, going back to your issue that you formulated, it would have been better to have been specific to say, do mere words constitute an assault? Because that is the issue regarding that television one. That's why I said when you start answering, I will tell you how your issues can be more specific. So you said is this an is that I mean whether Honorable Eggy is liable for assault for what he said on telly, but the legal language would have been the mere words constitute an assault. Okay, can you hear me?
Yes, ma'am.
Yes, ma'am.
So the issues that you framed before, you see that they were too general. That one was, now you have said the real issue. You said that he's coming to get him. Would it be assault? There's still something else around that one. Tell me the principles again. When you are formulating your issues, be thinking of the principles. All these, but this one, but in this case, it was said that this. Yes, Grace.
Sorry, good morning, ma. I want to raise another thing that I noticed from this particular question on assault. And I noticed that I think one of the things I learned about assault was that it should be direct. So in this case, the threat was not directly to Professor Small, it was to his family. So I think that's another thing that we should consider.
So if there is a threat to your family, is it an assault?
No, ma. Because it's not direct and personal.
Is that the meaning of direct? How do they define direct and personal to you? Anyway, note that. So she said that it's not a direct threat to the person. Okay? So it will not be assault if you threaten a member of the person's family. So note that and look at your notes again. Now, still regarding that assault, what else were you taught? She has given you the lead in that assault, in that assault scenario. What are the other principles that you were taught?
Would the threat put would the threat of Professor Eggy put Prof Smalls in a reasonable fear of violence?
What do you mean by reasonable fear of violence? Did they teach you about something about the person must have a present ability to carry out the threat?
Yes, ma'am.
They taught you. Okay, somebody threatens you on television or it's in US and it's threatening you, I'm coming for you in Nigeria. Would it be an assault? The issue of present ability to carry out your threats. Because it's on telly, said I'm coming for your family and wife and children. So now, looking at the law, you see that your issues can be more specific when you are looking at your facts and you are thinking of the principles of law they taught you. Would it be assault where somebody just uses mere words to threaten another? Do mere words constitute an assault? Is it an assault to threaten someone's family rather than that person? Is it an assault when the person is not proximate to the person threatening, there's no present ability to carry out the threat. Are you listening to me?
Yes, ma.
Yes.
But ma, I have a question, ma. Please, ma, on that present ability to carry out the threat. We had two cases. There were like two cases under that. Tubava versus Savage, and the other one where he wanted to like break his wife's head. Both of them, in my opinion, they were very similar, but the court reached different decisions on it. So I want to like know the distinctions between those two cases, ma.
If the court reaches different decisions, what do you do with those decisions in your legal system? It's for you to, I've told you regarding tort law that it's about logic, it's about social development, social interaction, and it's about the kind of court that you are sitting in. So if you have two conflicting decisions and you cannot determine, and you do not see the difference in the two, and there was no attempt to differentiate, are they from the same jurisdiction? Did the court differentiate them? If they didn't differentiate them, if they are from the same jurisdiction, which decision will take precedence over the other? Those are basic things that knowledge of legal system would have taught you. And so if you have the one that is the latest as against the one that is from a higher court, which one will you follow? I hope you are understanding me. Don't forget your knowledge of legal system when you're analyzing cases. And if they are from jurisdiction, did you hear what I just said?
Yes, ma'am.
No, ma, please.
So,
My network was cracking.
I don't know who is speaking now. So anyway, so the issues that you have picked out, if you relate those issues to if you look at the facts of a case, lesson that you are learning is that your issues can be more specific than just saying, is this person liable for assault? Is this person liable for battery? Can there be false imprisonment? Yes, those ones may be issues, but if I have 2 marks or 1 mark for each issue, and somebody is more specific and says, does mere words constitute an assault? I'd rather give that person the full mark than somebody that says, does the action of Honorable Egi constitute an assault? One is more direct, because when your issues are direct, your answers are sharper. And that's why I said, let's go to the law, and then we go back to the issues that you have formulated. When you are looking at the facts of a case, be you looking at them with the eyes of the principles that they've taught you. When they've defined those taught principles for you, or they define the concept for you generally in any of your subjects, maybe criminal law, it may be CT, it may be anywhere. Yeah, they've told you the definition, they've told you the elements or the principles. Then they will begin to discuss to you some of the things that have happened in practice. Okay, this one, in this case, the person did not know that he was imprisoned. And so the issue of knowledge is important. That issue of knowledge is not part of the element. Those are the things that usually form part of your questions. This person, the water was done as it was thrown accidentally. They said it was whatever, but it was mistaken as to the identity of the person who wants to throw it to. So is it mistake that can be, does it remain false imprisonment? I mean, battery. You read the elements, but you also read those areas that they've used cases to explain, because the elements are there. Then those other areas where the elements are being applied in practice are what the cases address. You can not just climb the elements and then you don't look at those application issues. So what I am saying is, you have picked your assault question, you have discussed the meaning, what an assault is this, and you give authority. You don't just define it yourself. Tell us where you got your definition from. The elements are A, B, C, D. Very short. Then you look at the aspect of assault that is relevant to your question and begin to apply it, because that's what the examiner is waiting for. Definition, conceptual clarification, yes, we've done that. But now, it will therefore be assault, or it will not be assault, depending on your view. Whether if you throw an object at someone that, then is not an assault, or is an assault if you just pick words, mere words constitute an assault. If you have not been taught whether assault, or you don't have any authority or principle relating to threatening of family members, then you might say, well, it has been said that what constitutes an assault, and these are words, and ordinarily constitute an assault. However, because they are addressed to family members, we do not have authority directly on that, then you show your ingenuity by telling us, well, if you were the judge, do you think it should be an assault? When you say, looking at the definition of assault, that you cause someone to apprehend a battery to themselves. Okay, I have many hands up, and I want to go to the next question. All these hands, either you want to answer our question or you want us to go to the next. Enewu. Emewu.
Good morning, ma. Yes, ma. Please, can an issue be raised around the fact that, because one of the elements of false imprisonment is that mere words does not constitute false imprisonment. And looking at the facts provided in the case, he said that the professor has refused to resume lecture, so his movement is kind of restrained. So can we say that the mere words given by Honorable Tweet on the television, does it amount to false imprisonment or?
Whether mere words constitutes false imprisonment. Now, what is the principle regarding words and false imprisonment? Can words
The principle,
false imprisonment?
the principle is that, like, general bare words does not constitute false imprisonment, that they must have done some actions that shows that the person wants to carry out the false imprisonment.
Hello?
Yes, ma'am. I said the principle is that mere words does not constitute false imprisonment, that the person
Now,
must have done other things.
the context in which these questions are being asked. Prof has been in morbid fear and has refused to come to work. What caused him not coming to work? In what circumstances and cases? Do you have the cases where words constitute, where you held to constitute false imprisonment or not constitute false imprisonment? If you are on the road, if somebody is on the road and says,
good morning, ma.
if you move, yes.
Good morning, ma.
Good morning. Who is that? Good morning. Okay. So be here, you are
To
disturbing us.
clarify the sorry, it's I just want to clarify the issue surrounding the mere words and whether it constitutes an assault or not. So the basic thing is that mere words actually does not constitute an assault, but mere words coupled with threat can actually constitute an assault. And for assault to be established, contact is not necessary. It could be necessary for battery, but contact is not necessary for an assault to be established. So where mere words are coupled with threat, then that would actually be actionable for assault. So and of course, Remilekun made reference to Tuberville and Savage and one other case. So if we check those two cases, the difference is that one was just mere words without threat, and then the other one was words coupled with threat. So, and that was why it didn't amount to assault in the first instance, but in the second instance, it actually amounted to words. And also there are where, because in this instance now, it did not just issue words, it was not just mere words, it was also coupled with threat. So, and since contact is not necessary, so the fact that he said it on TV does not make it less actionable for assault, because for assault to be established, not battery in this instance, contact is not necessary. That's one of the elements that's one of the elements for the establishment of an assault. I just thought that you just
Sorry, ma.
Who is this?
Ma, please, I would like to address Ebenezer. I really sorry, ma. Can I talk, ma?
Who is the person asking to talk?
Muturayo, ma.
You want to talk on what now?
What Ebenezer just said.
Okay.
I don't see any correlation with tuber violence savage in this case. If you want to lean towards the argument, I feel like we should go with Via and Sweeney, where a call was made to the plaintiff's house, and she was threatened that she would be arrested for being she was working with her fiancé who was suspected of being. So I think that is more related to the issue at hand and not to Babel and Savage.
What is the issue at hand? Because are you the one that asked that question?
Whether honorable
whether the threat is false imprisonment.
amounted to an assault.
You didn't say so. You said whether it amounted
Okay,
to
false imprisonment.
That's the point I'm trying to get at. You raised it around false imprisonment. You didn't raise it around assault. If you raised it around assault, and that's why I wanted to let Tobishi know, you raised around assault, and you have to be very careful. You raised around false imprisonment. He talked around assault. And what you said around assault would be in order if you are raising it around assault. But you said whether what can amount to false imprisonment. That's what you said. There are different issues. I hope you understand what I'm saying. There are different issues. What you said about what as constituting an assault and the cases that you raised are hypocytes. Even though you have to address the question of whether the temporal, the spatial difference in terms of not being able to carry out that whatever could have any effect on the assault. It's quite different from you telling us that whether we and words can constitute false imprisonment. And I was going to give you an example, and that's why I said you need to make those distinctions. I was going to give you an example. If a policeman tells you, if you move, I will shoot you, is it assault? And is it false imprisonment? The policeman stops you, cocks his gun, and says, don't move. You are not confined. I'm sorry, in false imprisonment, they've told you. You don't need to be confined in the four walls of a prison to be false imprisonment. So if a policeman met you and stops you and says, if you move, I'll shoot. And, is that, and so you are staying there and it's legally done. Let's assume every other thing is wrong. I mean, in terms of elements. What do you think?
Ma.
Yes.
Yes, ma. I think that is both assault and false imprisonment, ma.
Okay. So he has not locked you into any place. All he said is what? So can what constitute false imprisonment in that regard?
Yes, ma. What can constitute false imprisonment?
Okay. So what I'm getting at is that let's not confuse ourselves. The way the two of them have raised different issues. Be sure the issue you are raising is what you want to raise and stick to it and be sure that it is relevant. In this context, Tobishi, how do you call your name, has given us what he would say, and I agree with him in terms of the content of what he said. Let me tell you something. Everything that all of you have said has demonstrated legal reasoning. Legal reasoning. If you argue that way, you put the issue, you put the law, and you put your application of it. They are okay. So assault, you have discussed assault, and the question of whether you want to raise an issue around false imprisonment because of what and false imprisonment as constituting an assault, they are quite okay. Even when they've not given you the answer during the lectures and you are not sure, look at the principles and give an opinion. That's what we are looking for in the light of the law. Because it's not every time that the questions will speak to a particular case that has been decided. Thought is about human relationship and it continues to evolve. So if you get a question that does not have a direct case on, I can assure you, looking at the cases that you have been given, you'll be able to logically apply any of those cases to marshal your argument. So if you take the assault one, you finish those ones that deal with assault. You take the battery ones, discuss the ones that deal with battery. What are the ones that deal with battery? Somebody has told us. Now, the microphone hits a bottle of water on the table. The bottle broke and water splashed on a blue feet. What is the battery there? What object committed the battery? Is it the microphone or the water?
The water.
The water. Okay. So there's an issue of battery by splashing of water. Now,
Sorry, Ma. I'm so
let me
sorry,
tell you
Ma.
something. Yes.
Ma, please, when we are talking about the battery, shouldn't we specify if it's a direct or indirect battery?
That's exactly what I want to say. I've just raised the issue. You are the ones that will tell me the battery is committed by splashing of water. And I was just going to say, so what is the microphone eating the bottle of water on the table? What is it about? What is it about? Abisola Unite. Unite. Sola Adewale. Because the examiner is trying to see, direct, and discover something about your thought process. All those with their hands up. Is it that you have forgotten your hands there? Sola Adewale. What about Uche?
Morning.
Yes.
Okay, I wanted to say a different thing, but concerning what you just asked, the battery could be made directly or indirectly, maybe intercepted by maybe a third party in the case of, like in the case of Scott and Shepard. So in that instance, though he intended to throw at Professor Small and the microphone hits the water, that's like an indirect act of battery, but the water will still constitute battery in case of Purcell and on.
Do you agree with what
Ma,
she
did
said?
you get?
Do we agree with what she said? The battery could be direct or indirect. And she used Scott and Shepard. What happened in Scott and Shepard?
Ma, can I still answer?
Yes.
Okay, so just like in class, the lecturer clarified that the requirement of directness has been interpreted in court to be contact by a third party, and that's why I mentioned Scott and Shepard, where the defendant threw a lighted squib and then just thrown again by a third party, but the defendant was still held liable despite the third party intervention. So I would mention that case in the sense that contact could also be made by a third party in the sense that the third party does not need to be human, it could also be another object. Then I'm going to mention the case of Purcell and Onto, where there was a splash of water that constituted battery too.
Exactly. That's the point I want to make about the object, because we're talking about third party. That when it's an object, if you throw a stone at a tree, the stone is the tree, or a tree, and then bounces back and hits a third party and hits a plenty. Is that a battery? And you say, oh, it's at a tree that I threw. Now, when in terms of thoughts, one of the things you must take note is the fact that those things that they tell you about direct, it must be direct, it must be intentional, it must be negligently done. You know that the mental elements, you must take note of them and how they are interpreted in specific thoughts. For instance, they'll tell you these are intentional thoughts. What do we mean by intentional thoughts? That it doesn't mean that I must intend the consequences of what has happened. No. Intentional means as far as the act of doing the thing is concerned. You pick a stone and you threw it at the tree. You intended to do the act. You are not going to be talking about whether I reasonably foresaw that the stone will bounce back and hit the defendant, the plaintiff. So you cannot be arguing that I didn't intend to injure that person. So direct in battery is given a flexible interpretation. It's given a very flexible interpretation.
Ma,
And
sorry, ma. Can I add something to what she just said?
yes.
Okay, so I think if a stone is thrown at a tree and it touches someone, I think it could either reveal intention or negligence depending on the circumstances. The tree is close to where a couple of people are, or someone is like close to that tree, and the person throwing that stone sees or knows that someone is close to the tree and throws the stone, right? If he claims that there was no intention, then that would reveal negligence because if there's someone close to the tree, it's reasonably foreseeable that that stone could possibly hit the person standing close to the tree. And if
Yeah,
there's
I agree with you that the context might determine. And a good lawyer will not just sue for battery, but will also the alternative sue for negligence. But in the context in which it happened. Now, intention means voluntary. Okay? In the context of most of the thoughts of trespasses. It is voluntary. And it relates only to the action of the defendant. It's not necessary for you to foresee consequences of what you are doing. Who is disturbing us now? Aisha, please, why you stop singing? Please, somebody is listening to class and is singing. Why did I stop, Gary? Okay. So when you're talking about intention, I want you to note that for instance, each thought has its definition most of the time. So what do you mean by intention? So I'm saying that you have said battery is application of force intentionally, immediate and direct means to another. And then you know the elements. So I was saying that intention means it must be a voluntary act. And it relates to the action of the defendant. And it doesn't, not necessarily the effect of the action. And I think you can see cases like Fowler and Lanning, Oyakiri and Obaseki, and I can't remember some other cases I can refer you to now. I don't know if they gave you Holmes and Maja, about intention. And there's also the principle of transferred intent, where even when your action intending to hit A, for instance, you now hit B, the intention is to hit A is transferred to B to make defendant liable in battery. Then we say direct, and I was saying that if you get a flexible interpretation, like the example you give us on Scott and Shepard, and then you also notice something that intention in battery to be formed at the beginning of the act and to be formed at the subsequent to the act. Like the case of Fagan and Metropolitan Police Commissioner, where there was negligence before in driving onto the officer's foot. I don't know if they give that case. And then he refused to move the car for some time before, so it became an intentional thing at a point in time. The initial act was negligent, so it became intentional, and then so those little details, you must take note of them. In terms of what is the mental element of a particular course of action. Can you hear me?
Yes, ma.
Yes, ma'am.
Please, ma, I have a question, ma. Please, does what you're saying mean that battery cannot be reckless or negligent? It can only be intentional.
I'm sure you know that there is controversy about that. In the light of what I've said, however, when we say in terms, if it is a voluntary action, it is construed as intentional. Whether it is regarded, that voluntariness is regarded as negligence, because once you introduce negligence, you are then giving a room for escape and say, okay, it's not reasonably foreseeable. But when you say the act was done deliberately, as opposed to not being intentional, And that's why I'm emphasizing that intention, the definition in the light of the cases. Okay? That is, once it's a voluntary action, it is construed in relation to the action alone and not in relation to the mental state with which he did the action. So if I go, let me give you an example I normally give in class. So if I get downstairs in the faculty, I'm going out and I want to enter my car. Then, I just get downstairs. I just walk towards my car. And I try to open the door. And after I try to open the door, that's when I can now see that, and I realize it's not my car. It's exactly like my car. It's parked where I normally would park my car, but I wasn't really thinking. Maybe I was talking to a colleague, so I just went towards the place, forgetting that I didn't park directly there. That day I parked at the next parking spot. Would it be negligence on my part that I tried to open that car, or was it trespass? Or is it trespass?
I think it's trespass because it's a voluntary action.
You think it's trespass because of what?
Because the action is a voluntary action.
It's a voluntary action.
Yes, ma'am.
But I cannot argue that I didn't intend to, there's a trespass on the car, so to say, to take your car away. In that context, it is trespass. I agree with you. If you look at it in the light of the definition of, if you want to translate it to negligence, is there a duty of care? Is there a breach? Is there a damage? You will not be able to succeed in negligence. You will only succeed in trespass. Because one core thing that will not make you to succeed is that element of what?
Intention.
Beyond the intention, I'm telling you the trick to get it right. Because who thought it's tortious? When they say tortious, it's twisted. What is that thing that will not make you
voluntary?
It's voluntary. It's a voluntary action. Abi, okay, so it is voluntary on my part in terms of what I did. So you think because of that, and negligence, usually you did not take your duty of care as a reasonable man would do. So you would say a reasonable man would have checked the car very well. Every time I go down, I will check very well. Maybe I'll check the plate number of the car before I enter the car, since the two cars look the same. But there's something that is critical that will make you to know that I'm not going to go and sue for negligence in this case. So that when you are confused about that voluntariness and that whatever, and that intentional aspect, you have answered the question right, but I want you to get the trick and give me one principle in negligence that will make you not to sue in negligence. Even if your other, pardon?
Duty of care, ma.
Duty of care.
Damage.
Damage. Yes. Because negligence, there must be damage. So there's no point. You as a plaintiff paying for what you will not succeed in. I tried to open the door. Nothing. There was no damage. Nothing. I did not spoil the car. I just put the key. I know the slightest touching, even as transportation. Moving, I pick your phone, I move from here to the next room. I didn't steal it, I didn't do anything. Nothing happened to your phone. No, can be battery. Sorry, can be trespass to boot. So damage will help you to even streamline your course of action and say, this person has suffered nothing. Meanwhile, in the trespasses, you don't need to have damage. Am I right? Am I right?
Yes,
Yes,
ma'am.
ma.
Yes, ma'am.
Yes, ma'am.
So those are some of the little the devil is in the details that will make you to know that this course of action can only be founded in trespass and not negligence. And so whether it can be done negligently or not or whatever will not become an issue for you. If they give you an essay question you should argue both sides of the point. That means the essay question. And there are cases that say it can be done intentionally only, and some say no, it cannot be done intentionally and negligently. You give us all the cases and from your own view, as to whether arguments are tenable. Because in essay questions, you want to see your own creativity. You want to see your own perspective. So you can give us all the things that the judges have been saying and the courts have been saying and form an opinion. And we discuss that in the light of your own opinion. That's just part of it. Okay. Now let's go on to the next question. So I've told you we are not answering the questions in terms of the details, but I want us to argue. Now let me also to know how to tease out your issues and answers and whatever. So the structure is good. So you have a problem question. Please read the question at least 2 times, if not 3 times. Don't be in a hurry to start. Read it very well. Who are the parties that they mentioned here? What did they do? That thing that they did, what does it represent in court? It will tell you, it will make you focus on the course of action. Usually, these questions are standing alone questions. So if you have a question, you can have a question that is trespass generally, then trespass to person, trespass to goods, trespass to land. But usually, if you are students studying the lecture structure, with 4 lecturers teach you, each lecturer taught a particular topic out. They are not going to mix their answers, the questions together. But if I taught you trespass and I taught you negligence, I can mix it together. So all your courses, look at them in that way. If you are taking CT, how many lecturers are teaching you? What did each lecturer teach? The part that each lecturer taught. Once you see it in the question, watch out for that other part that the person has taught as well. Maybe they have mixed it together. So look at all those components to be able to also, so there's a psychological part to exam. So that will help you to know, okay, I think I would have picked everything. So if I taught you negligence and somebody else, or body not came to teach you of bias liability, you are not likely to find bias liability inside negligence. If Adekile taught you trespass to land, you are not going to find trespass to land inside negligence. If she taught you trespass to land and trespass to goods, you may find the 2 of them together. I hope you are listening to me.
Yes, ma'am.
Yes, ma'am.
Yes.
So those are some of the details, some of the psychological aspects, or that you can use to rely your thoughts. So you now have the question. We have started with the statement. This question relates to trespass to persons, and covers every aspect of it: assault, battery, false imprisonment. The issues that relate to assault are these. You have your exam script. The exam script, you can do your rough work there. You see it there. Don't write your questions. Don't do anything on your question paper. Do it on the exam script. The back of the exam script. Structure it out. As you say, okay, engineer, okay, this person, he did this one did this one. Pick out what the person has done. Look at it together, then create the ones concerning assault, the one battery, false imprisonment, then arrange it in that context, in that order. So the one that deals with assault. The examiner too, once they see that, okay, you want to deal with assault, they look at for everything you have to say about assault. Finish that one, go to battery, finish that one, go to false imprisonment. And as you are writing about each person, tell us if they are liable. Oh, honorable, is it liable or not? You must always end up with liability statement. That's when you go, that's your conclusion. Is liable in assault for throwing flashing water. Is this person is liable. The Bansa or the retreat are liable for false imprisonment by locking up the person, or they are not liable because there's a reasonable means of escape, or whatever you want to say. Have a statement that gives us your opinion. Because if you go to court, the judge is going to say you are liable or you are not liable. That's the whole end of the discussion. It's not just all the argument, but you must give us the law. The law. Don't give us is liable or not liable. You are telling us the meaning of assault, the meaning of battery, or the elements. And then how you say it depends on the focus of the question. You tell us definition, give us authority. If there's focus classifiers, that will be sufficient. Give us that elements are A, B, C. They may give you many elements. If your issue focuses on the 3rd element, is that 3rd element you explain very well regarding the issue that I'm giving you. Doesn't mean, because it's not an essay question. So the elements are these of assault are A, B, C in particular, and you explain A means this, B means this very briefly. If the focus of the question was element 2, then that's the one you take time to give us the various aspects that are relevant. We'll go to the next one. I think we should leave that question. By the time we take another question, you'll be able to further. Actually, our time is gone with one question. Further answer. So I think we'll leave it like that. During when is the next time I'm seeing you? I think I'm seeing you tomorrow, right? I'm seeing you by hearing from you. Can you hear me?
Yes, ma'am, can hear
Yes,
you.
ma'am.
Now we can hear you.
Okay. Are you okay with what I've said now? Did you hear everything I said?
Please, I have a question.
Yes.
When crouching our issues, if we don't necessarily like crouch it with the principle, but we later state the principle in the issues, like, is that fine?
What do you mean by principle? What do you mean by
Like, we're like, it's better we crouch it like do mere words amount to assault. But if we don't state it that way, but we later like put it in the issue, is that fine?
can say, is this assault? The mere words is the real issue that you are looking at. And I said the details, the one mark here and there makes a lot of difference. But some of you will say, I got 47, I should have gotten 50. I got 56. If you are giving me for 60. Those little details. If you can pick it directly, that's why you see that way by the time we started discussing the law, you were able to see the issues in clearer form. The issue, students usually will say, is there, they will say, is Honorable Egi liable for assault? Is Honorable Tweet liable for false imprisonment? Is Professor Smith liable for this one? Those are too generic. I'll still give you a mark, because I think you know he's dealing with assault or battery. But which is the exact aspect? What is, sorry, pardon my vernacular. What is the core of the issue? The examiner knows it is assault. Is a question posing on assault, but what exactly? What is the problem regarding assault? In court, if you take somebody to court, and it applies to every aspect of the law, that's why students seem to believe that they don't do as well as they intended. You say somebody has been arrested for murder. You take the person to court. You will not go to court and say the issue is whether this person is liable for the murder. That is the general issue. In academics, when we are talking about objectives, there's the general issue, is he going to be liable for murder? That is the end of the result. That is what the trial will decide. But the lawyers will be arguing. The issue, somebody is liable, you arrest somebody for murder. Yes, he killed, the facts are clear. She killed this man. She killed her boyfriend. It is clear. She was caught in the act. She was caught in the act. So nobody is denying that did she kill. So you are not saying to court and say the issue is, did she kill the man? That's not an issue. You are looking for, as a lawyer, what are the legal problems around this killing of the man? So somebody might say, would it be murder when you kill in self-defense? Would it be murder when the person was provoked? So you are formulating issue around some principles of law. Maybe because the person, you see, there was evidence that she was trying to defend herself. And then, even beyond the self-defense, there could be question whether the defense was proportionate to the attack. Somebody tries to slap you, and you take your gun and you shoot the person. So it will border on not just false defense, whether the defense is proportionate to the attack. Sorry, I'm delving into criminal law, but I do that because I know you do criminal law, you sit as compulsory questions in your credit. So when you take it to tort, you can be very specific. This person locked somebody in the house for 3 days. On the face of it, prima facie, you'll be thinking of false imprisonment. But they tell you that he locked the person in the house for 3 days by locking the main door. But the fact shows that the person that he locked in the room was in coma. And that's why she said, this person is in coma or is unconscious. The person will not know that I locked the person. Let me quickly go to Ibadan and come back. He will not wake up out of coma. He's been in coma for 10 years. So the issue has not beyond that. Is it false imprisonment to lock somebody in the house? What will the issue be now? It's gone beyond that. A more specific issue that a first-class student will frame will revolve around whether the knowledge of imprisonment is.
I have a question, ma'am.
Did you hear what I said?
Yes, ma.
No.
Okay. If you didn't hear, you hear me tomorrow when you are taking to breakfast. Yes, final question. All right, let me call it again.
Question. I have a question. Okay, ma. So, ma, for the sake of clarification, if a problem question is presented to us, and at the end of it all, like let's say you've applied for Iraq, and the question says advise both parties, and it's a problem question, what is the suitable advise both parties?
Yes.
Like, what is the suitable mode for conclusion? Are you supposed to say like are you supposed to say after everything like that you've said, that after the like principles that you've laid on, are you supposed to say I think this and this should happen to this person, or are just
if they say advice you see, the problem with students is that you sometimes you hold some things too serious. If two people are fighting in front of you over something and you want to advise them, you give your clothes to a tailor. Your friend gives a cloth to a tailor. The tailor brought the clothes to the hostel to meet you, and then the friend rejects the cloth and says, the bust is too tight, or it was not a button down that I said you make. I told you to make a dress, but it was not buttoned down, that it was to be zipped at the back. And the tailor has brought the clothes, and she's rejecting the clothes. You want to settle the matter. What is the issue that you raise? Are you going to say the problem is whether the tailor has brought the clothes or whether she has sewn the clothes? Has she not sewn the clothes? She has sewn the clothes. Has she not brought it? She has brought it. The issue will relate to what?
The style of the clothes.
The style of the clothes. The style. They are fighting. And this clothes, I reject it. I will not take it. You must take it. You must pay me my money. They say, come and adjudicate. What happened? What happened? I gave her the clothes. Oh, I told her to make a zip up at the back. She has made button down. The tailor says, no, it's button down. So they are fighting, not over whether she has sewn the clothes. I'm not saying you didn't sew my clothes, but see, that's not the style. They're fighting over the style. The style is the issue. Now, advise the two parties. What is the advice will be indirectly the same thing. Oh, the person that says that's not the style may show you evidence. It happened to me. Look at the style I sent to him. Shows you what's that picture. The tailor says, you sent me this, but later you change it. I see the one that I sold me. You as a person, you look at the dates, look at their conversation, you look at, you try, and then you advise them and say, excuse me, I think you should pay for this cloth because yes, you sold that to tell but later you can say you changed it. Maybe you forgot you changed it. So I advise you pay the money. That's the advice that covers the two of them. If now they tell you this person wants to sue and the other person wants to sue the person, and the tailor is contemplating suing your friend, and they say advise the parties. We are just asking you to discuss the issue and the law. So I will advise that you can actually bring the course of action and successfully against this person. That's the advice for the two parties. Sometimes I think you should calm down and just look at these things in the natural scheme, because thought is about things that happen to you. Do you understand? Advise the parties. If they tell you this person is arguing, so the facts of the case will help you. They may tell you this person is arguing that the clothes that she told me to sew is button down in the front, and she has brought the evidence. My advice is that in light of the evidence forward, she's right to have sewn this thing, and she can successfully bring a course of action for whatever you want to breach your contract or whatever. This person, if you can say that, I will advise the other person that she does not have a legal claim because the evidence suggests that that is not the thing she told her to do. You have advised the two parties. Those statements, maybe it's 2 marks at most. You are through with those ones. Is that clear? And if they say discuss the issues and legal issues in this case, you can still discuss in the same way. At the end of the discussion, you say, I think that Mr. Taylor does not have a defense and he should go and redo the work and like this and that. Those are just one or two marks that will never be here or there. You know, we just have different ways of framing the conclusion to the whatever. Now, assess these facts in the light of the issues arising in thought. If they say assess the facts, like the question we just answered, you assess the facts, you are still going to tell us, or maybe you ask who is liable or is not liable. They didn't say you should advise the parties, but you are going to say this person is going to be liable or has a course of action in thought or whatever. It depends on your language, but just make sure you say something to conclude the statement of the law. Okay? I really
yes, ma. Thank you, ma.
Okay. I really have to go now. I have another class. I hope that before the next class, you can actually have mini tutorials amongst yourselves and then come on board so I can take as many questions as possible. So we'll be seeing tomorrow, I think, to continue with the questions. Tomorrow we'll take another polling question, then we'll take maybe 2 essay questions so that I can have a balanced. Okay.
Well, please, what of the modalities for our test on Wednesday?
I can assure you that test, I'm not see Adekile. Go to Adekile for that. I'm not Dr. Adekile. Yes, we'll discuss with her. I'm not
Thank you very much for today, ma.
You're welcome. You're welcome. So I'll see you tomorrow by the grace of God.
God bless you.
Thank you, ma'am.
Okay, bye.
Thank you, ma.
Thank you very much.
You're welcome.
Thank you, ma.